Hey everyone, it's Mystery Girl and I'm Missy. Today we're getting into the Gabby Petito family versus the Laundries, the pre-trial. We all know the sad story behind Gabby Petito. I'm not going to get into the timeline, the dates, and all of that. That's already been out there. Everybody, I'm pretty sure, is familiar with it. I am going to go into a little bit of a background just for anybody that doesn't know. Gabby Petito went on a cross-country trip with her fiance, Brian Laundrie. They were traveling in a van that was hers, then they converted it so they could stay in it. During the trip, Gabby kept in touch with her parents, texting them. And Gabby and Brian Laundrie had gotten into an argument which resulted in bystanders calling the police. They did find them and pulled them over. During the pullover, Brian said that Gabby had hit him, because he had a mark on his face, and that he did not have a cell phone. When talking to Gabby, they did see marks on her face and a bruise on her arm. After a while, they questioned what that was from because she took the blame for hitting him, and they were going to arrest her at the time. At the time when the police pulled over, she did give the symbol with her hands. I don't know if anybody noticed. I know some people did, but she gave the symbol with her fingers on her hands that she needed help. But I don't think that it was noticed, or the police just weren't familiar with the symbol. Either way, they were going to arrest Gabby for hitting Brian, but determined that she wasn't out to hurt him, so they separated the two for the night. And Brian ends up coming back to Florida without Gabby. The Petito family called the Laundries numerous times, over and over and over. They were blocked on the phones, they were blocked on social media. They tried every way they could, reaching out to Brian's sister. Nobody replied. They then got a knock at the door, Gabby's mom, and it was determined that Brian had come back without Gabby. Now there was a search for Gabby. During the search for Gabby, another van family caught on camera Gabby's van and was able to send that to the police, which determined where Gabby may have last been. When looking into it, they did find Gabby's body. The Laundries still kept their mouths shut. They didn't speak up. Knowing that their son was home, they went on a camping trip. They made s'mores. He played with his nephews, visited with his sisters, cut the lawn, like nothing had ever happened. And then Brian went missing. The Laundries still did not speak up. After all of that, they, like I said, found Gabby's body, and then they did find Brian Laundrie's body in a campground close by, and he was determined to be dead as well. So we lost 2 young lives, and nobody will ever know why. There is a notebook that they found in the trails where conveniently the Laundries knew exactly where to go. They knew exactly where to go to find Brian's remains, which to me is still a mystery. All this time, money, energy, everything, all this searching for him, and they just go out there one morning and boom, oh, here he is. I don't get that. It pisses me off. This family should have spoken up, no matter what. That's a mother and a father that should have responded to another mother and father that were in dire straits looking for their daughter. And now the Petito family is trying to take the Laundries to court for not speaking out and for holding information that would have helped them find their daughter and not have put them through so much distress. So today is the pre-trial because the Laundrie family, of course, is trying to dismiss this. And today is the pre-trial for the case that's not supposed to happen for, I believe, another year or year and a half, somewhere around there. So that's just a little background, a quick background on the case of Gabby Petito, Brian Laundrie, the Laundrie family and the Petito family. And before we go any further, I just want to send all my thoughts, all my prayers to the Petito family. And as everybody says, she's America's daughter, and her tattoo, let it be. But Gabby, you have shed light on DV for so many, and you have opened eyes to so many. And your family has started a new foundation in your name. Rest in peace, Gabby Petito. You will forever be remembered and loved by your family and those that didn't even know you until your face showed up on the news. It was amazing how a whole entire community came together to try to help find you and to bring you home to your mom and your dad and your step-parents, those who loved you so much, for it to end in such a tragedy. Gabby, you will forever be remembered by everyone. And we just hope that you are resting in peace and that justice will be served.
Filed by the parents of Gabby Petito against the parents of her suspected killer and then fiance and boyfriend Brian Laundrie will head to court for the first time today. Her family is accusing the Laundrie family of causing them emotional distress. They say Christopher and Roberta Laundrie knew their son Brian murdered Gabby but didn't tell detectives, refused to help in the investigation, and then went on vacation. The Petito family said the Laundrie's behavior, quote, goes beyond all bounds of decency and is regarded as shocking, atrocious, and utterly intolerable. As a result, Gabby's parents say they suffered pain and mental anguish. However, the attorney for Laundrie's parents says his clients had no legal obligation to discuss the case with anyone and is asking for a judge to dismiss the law.
So the Petito Schmidt family arrived approximately a half an hour early. And guess who's not going to be there? The Laundries. Their lawyer is representing them. So they are not going to be present in court. But at least right now, the Petitos and Schmidt are having a day in court. Let's pray it works out in their favor.
Your Honor, this case is not simply about the silence of Christopher and Roberta Laundrie, who knew that their son had brutally murdered Gabby Petito. It's not simply about their callous refusal, despite pleas from the Petito family, to speak up about whether or not Gabby was alive and if she wasn't, where her body was located. It's about a course of conduct that they committed from the moment they learned on August 28th of 2021 that their son had brutally murdered Gabby Petito up until the time that her body was found. And as this court has already noted and pointed out, that includes the statement that was made the one time they decided to speak up. They spoke up through their attorney, and I'll touch upon the importance of that in a little bit. As the court knows, you're bound to accept as true all of the facts alleged in the four corners of the complaint, and I'd just like to review what some of those allegations are.
Well, let me ask you this, Mr. Riley. And let's lay aside the statement that the attorney made on behalf of the Laundries. What duty did the Laundries have to do anything to help Mr. Petito and Ms. Schmidt?
That's a fair question, Your Honor, and I've struggled with the answer to that particular question, and I guess maybe by answering this I'm deflecting, but my answer is this. It's about what they did with the information that they have, not just not disclosing what they knew to the Laundries. And by the way, they could have, to the Petito family, they could have made an anonymous phone call and said where the body was located, and that would have would have helped this situation tremendously. They knew, starting on August 28th of 2021, that Gabby was dead. They knew where Gabby's body was. They knew that the Petito family was desperately searching for information, but they did things affirmatively. They didn't just remain silent. Brian Laundrie came home in Gabby Petito's van by himself to his family's home. That family, knowing that Gabby was dead, knowing their son had murdered her, knowing where the body was, and in particular, knowing that Joseph Petito and Nicole Schmidt were desperate to learn where their daughter was located, they went on vacation. They assumed and continued their normal life as though nothing had happened, while this family was suffering, wanting to know what where their daughter was. Not only did she not...
Let's get back, though, to legal duty. I hear what you're saying, that these facts might sound bad, but we're not talking about social mores here. We're talking about legal duty. So let's try to focus in on what duty did the Laundries have? What did they owe to Gabby's parents?
Well, let's put in perspective what the relationship was, Your Honor. These people were not strangers. These people were, their son was engaged to marry Gabby Petito. Gabby had lived with them for about a year. They had both visited Joseph Petito's home and Nicole Schmidt's home. They were cordial. They had a cordial relationship, a warm and friendly relationship. They knew how much Gabby meant to Joe and to Nicole. Going to the issue of a duty, Your Honor, I struggle with that. I admittedly, it's difficult to say what it is, and that's why I'm saying there was a course of conduct that they did that was outrageous, culminating, in my view, in the statement that was made by their attorney, who, as Your Honor pointed out, is their agent. And what that attorney said in particular is telling. So there's no question that he represented, that he was making that statement on behalf of the Laundries, because he says, it is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming on behalf of the Laundrie family. It is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. That statement was issued with the full knowledge and consent of the Laundries, with the full knowledge on the part of the Laundries that Gabby was not alive and that Gabby's body was located somewhere out west. And instead, they make a statement saying, we hope you find her. We hope you're reunited, giving them false hope that perhaps their daughter is still alive. If that's not outrageous, Your Honor, I don't know what is outrageous. So I think when you talk about their affirmative duty to speak up, I struggle with that. But they did speak up. And when they spoke up, they made that very callous, that very terrible statement, giving hope to Joe and Nicole that perhaps Gabby was still alive, with full knowledge that she was not. And Judge, when I talk about the course of conduct, I want to talk about some of the cases that I cited in my response to the motion, where the court found that there was outrageous conduct. And I don't see how any of these cases are by any stretch of the imagination, worse than what happened in this particular case. In the McAlpin versus Sokole case, a patient went to a hospital to have an x-ray done. She put on a hospital gown. She walked into the x-ray room, and the minute she walked into the room, the doctor began berating her in front of other staff because she hadn't paid another doctor's bill. He told her he wasn't going to treat her, and he told her that he was going to call security and have her removed from the hospital. That, according to the court, was outrageous. In Nims versus Harrison, a teacher, two students of a teacher wrote, published, and circulated a newsletter in which they had an article called Low Life, and they referred to that teacher in offensive language, threatened to kill her, threatened to rape her children, and threatened to rape their cousins. Outrageous. Ford Motor Credit Company versus Sheehan. Collection agent is unable to locate the debtor, contacts the debtor's mother tells the debtor's mother that she's from a hospital out in California. She's trying to locate the debtor because 2 of the debtor's children had been in a serious car accident, and she wants to find the debtor so that she can let him know about this accident. The son speaks to the mother later that day, hears the story from the mother, spends the next 7 hours calling hospitals and police departments out in California, only to find out that this story was false. That was outrageous. The Dependable Life Insurance Company versus Harris case was talked about previously. In Liberty Mutual versus Stedman, the company delayed authorizing a lung transplant even though a judge of compensation claims had already ordered that they pay for the lung transplant. The carrier knew she would die without the lung transplant, so hoping the problem would go away, they denied payment in an effort to intentionally induce stress on her part to speed up her demise. The court said, under the totality of the circumstances, it's outrageous. Williams versus Mineola, and it's these 2 last cases that I'm going to cite the court to that I think are most instructive here. In Williams versus Mineola, police officers attended the autopsy of a teenage boy who had been murdered or committed suicide, and they were there with a videotape, a video camera, and a camera to record it because of the suspicion that a crime may have been committed. They took that video, they took those photos, and they took them to a party. And at the party, they shared them with other persons, including other police officers from surrounding jurisdictions, and they laughed and they joked about what was in those photographs. The court found that to be outrageous, and here's what the court said. As for what is outrageous or reckless or what is not, we emphasize that our society, as reflected, for example, in decisions of the courts of Florida cited earlier in this opinion, shows a particular solicitude for the emotional vulnerability of survivors regarding improper behavior toward the dead body of a loved one, and the special deference paid by courts to families' feelings where rights involving dead bodies are concerned is central to our decision. This area is unique, and once it has entered, behavior which in other circumstances might be merely insulting, frivolous, or careless becomes indecent, outrageous, and intolerable. One obvious reason is that the bereaved are already suffering psychic trauma because of the loss of a loved one, and are especially sensitized to any disrespect or indignity directed at the deceased body or a representation of it. The potential for severe emotional distress is enormously increased in that situation. All of this is well known to the ordinary person, and so a level of carelessness or callousness which might not be considered tortious in other situations can show outrageousness and recklessness when a dead body or a picture of a dead body is involved.
Well, Mr. Riley, how is a statement, "We hope this search is successful," how is that in itself outrageous?
It's a lie. It's said with knowledge that there's no hope of finding her alive because she's dead. It's said with an intention to give false hope to a family that their daughter may be alive. That's outrageous. And at this particular point in time, they had been begging the Laundries to tell them where their daughter was, and this is the statement that they issued. The one time they chose to speak up, this was the statement that they issued. A lie that gave false hope to Gabby's parents that perhaps she might be alive. The other case, Your Honor, that I think is instructive is the Thomas versus Hospital Board of Directors case, and I think this one may be even more instructive. In that case, during I believe it was a hip transplant surgery, the decedent died. She died of cardiac arrest. What she really died, the real reason she died of cardiac arrest is because she was given an overdose of a particular medication during the surgery. And the doctors and the nurses agreed that they would not report the true reason for why she died. They would say that it resulted from complications of surgery. As a result, the complete autopsy was not done. The body was released to the family, and less than a week later, as the decedent's daughter was trying to bury her mother, she received a telephone call from the medical examiner saying, "You need to bring that body back immediately. We have to perform a complete autopsy." Again, the court said that was outrageous, and what the court said was, "We believe that the appellee's conduct in making false statements," and isn't that what Mr. Bertolino did on behalf of the Laundries here? We believe that the appellee's conduct in making false statements which led to the interruption of Mildred Thomas's funeral and the return of her body for a second, more thorough autopsy rises to the level of atrocious and utterly intolerable behavior which cannot be condoned in a civilized society. As noted in Stedman, when an actor has knowledge that the other person is peculiarly susceptible to emotional distress, and the Laundries knew that because this family publicly said they were distressed trying to find their daughter, the actor's conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge. We believe that in a situation where a person's loved one has died, it would be apparent to anyone that the person would be susceptible to emotional distress, and therefore that the action of providing false information concerning the loved one's cause of death meets the standard for a claim of outrage. In this case, they provided false information, a false impression, knowing that Gabby was dead, that she was still alive and she could be found by the family if they were searching in the right place. So I also think under the restatement of Tort Section 46, comment F says, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the action proceeds in the face of such knowledge, where it would not be so if he did not know. And that's basically what the Williams court was saying, and that's what I'm saying in this instance. The Laundries knew of the fragile emotional state of Joseph Petito and Nicole Schmidt at the time that that statement was issued. They knew that she was not alive. They knew that the family was hoping to find her, and they put out a statement as though they were supporting them, saying, we know she was our son's fiance. And we hope that you find that body too, or you find her and the family is reunited, That's callous. That's callous, it's shameful, and it's outrageous. And by the way, the only reason that Mr. Bertolino is not a defendant in this action is because he's not a citizen of the state of Florida. I think there's also support for our position under comment E to the restatement, which says unequal position of the parties in a relationship where one asserts and has the powers to affect the interest of the other may also supply the heightened degree of outrageousness required for a claim of intentional infliction of emotional distress. Here, the defendants clearly had the power to affect the interests of the plaintiff because they could have told them where her body was located, and they chose not to do so. Your Honor, I don't think there's any question. There's been nothing raised, at least by counsel in his argument, that the conduct didn't cause severe emotional distress to my clients. To the extent that they would suggest and have suggested, well, they were already distressed anyway. So all we did was increase their harm. I guess it's okay to kick someone when they're down, according to the Laundries. But going back to those two cases that I cited earlier involving dead bodies, the parties were already grieving, and it was the conduct after death that the court found was outrageous and permitted the case to move forward. So I think we have the issue of their conduct was intended to harm, or certainly what they did, they should have known was likely to cause severe emotional distress to my clients. We clearly have an outrageous conduct on their part. I think we have established that the conduct caused more emotional distress. It doesn't have to be the only cause of their distress. If it increases, that's sufficient to recover. And I don't think they're contesting at all that the emotional distress was severe. So I'll move on to the suggestion that the defendants get to raise affirmative defenses at this point.
Within the four corners, and effectively you alleged conduct which arguably could be considered criminal on behalf of the defendants. So why can't I consider the Laundrie's constitutional right to remain silent and other constitutional rights within the context of ruling on this motion to dismiss.
Well, Judge, I'm curious to find out what conduct it is that the complaint says the Laundries committed that was potentially criminal. So if the answer is they were harboring a fugitive, there were no charge. Again, we're outside the record, but to my knowledge, or outside the four corners of the complaint, but the complaint doesn't allege that there were any charges pending against Brian Laundrie at the time. So they couldn't have been harboring a fugitive. Are they?
I'm not sure the absence of charges is the criteria that we use.
Well, Judge, what this is forcing me to do to address that is to go outside the record, which is not what we're supposed to do, to say he wasn't running. According to everything we know, the police knew where he was. So he wasn't a fugitive, so they weren't harboring a fugitive. I don't know what were the accessories after the fact. I don't know. Is there something they want to confess to? I'm happy to hear it, but I don't know that anywhere within the four corners of the complaint there's a suggestion that the Laundries were under investigation for a crime or that they had committed a crime. So, first of all, I think we shouldn't even be considering this as an affirmative defense. Secondly, you can't look at the complaint and determine was there an investigation into them and what were the crimes. So I don't think the Fifth Amendment applies. They retained Attorney Bertolini, and Attorney Bertolini said what he said on September 14th of 2021. So we're not saying they shouldn't have hired an attorney. We're not saying hold it against them for hiring an attorney. I'm simply saying they hired one immediately after getting a phone call from their son, who then returned home without Gabby. Circumstantial evidence to show that they knew. That's the only reason that I raised that issue about them hiring a lawyer. Your Honor, unless you have any other questions, I believe I've covered everything I wanted to cover.
Thank you very much.
Thank you.
Mr. Luca, I'll give you 2 minutes for any.
Point you to, with regard to that City of Mineola case, Your Honor, there is a second DCA case, Crenshaw versus Sarasota County Public Hospital Board. I think it's cited in both my motion and the.
So the judge concluded that it's going to take at least 2 weeks for him to render his decision. I apologize. I had the whole entire hearing on video. My phone ran out of space. So if I was going to delete anybody, it was going to be the Laundrie attorney. So I had to do that. I do apologize. But all he basically did was talk about the First Amendment, the Fifth Amendment, and the judge did go back at him stating that Bertolino spoke up. So isn't that speaking up in some way? But I do apologize for not having the whole trial. I did get the video footage from WFLA.com now. And I will definitely keep you informed of all information that comes when it comes. And I just want to thank you again for all your support. Thank you for watching my videos. Don't forget to give them a thumbs up, subscribe, and hit that notification bell. This way, when I do put up a new video, you get it. And that's right, Gabby, you are irreplaceable. Until next time, guys, remember, every day is a mystery.